Hey, good morning, everyone. Thank you so much for joining us today for our weekly trade and tariff briefing. I'm Rayanne Ripple, the Senior Manager of Events and Partnerships at World Trade Center, Utah, and I have the pleasure of facilitating our discussion today. If you're here for the first time, this weekly webinar series is intended to provide you with the latest information around trade and tariffs. And we'll throw some links in the chat where you can view previous webinars on our YouTube channel and find updates on our tariff dashboard on our website. Today, we're excited to hear from Troy Keller, who's a partner at Dorsey Whitney law firm, and his colleague and fellow partner at Dorsey Whitney, Dave Townsend, who will talk about the topic of transshipments. But before we dive into that, we'll hear from Troy first on some updates on the tariff dashboard. So it's all you, Troy.
Thanks, Rayanne. Good to be back. And again, somewhat thanks to World Trade Center Utah for organizing these. We keep thinking there'll be a week when there isn't as much to talk about, but boy, it never disappoints. There's plenty every week. So I'm going to do these updates as Rayanne mentioned. They are on the tariff dashboard, and always which is always immediately updated and a great resource. Um, uh, One of the first ones to mention, there's been the Section 232 review process. The comment period for that ended on September 9th. This is the review on wind turbines, with the expectation that there'll be some tariffs, special tariffs placed on those, sectoral tariffs on imports of those at some point in the potentially near future. So implementation of that could begin as early as next month, or as far out as early next year. Um, on the reciprocal tariffs, and we'll get to the Supreme Court case update there, but in the meanwhile, the Trump administration, the White House published an executive order almost a week ago that was super interesting. Folks will remember the annex on the first one that had a number of exemptions. They've updated that, both in terms of removing some exemptions and adding others. They also did something very interesting where they added a schedule with a number of additional potential exemptions, and the guidance on that was basically to pave the way so that USTR and Commerce, as they're negotiating trade deals, it's a bit of a carrot there. If other countries participate in sort of a favorable way, then some of those additional exemptions could be applied on specific products. So what we've been talking to folks at companies that we work with, advising them to stay close to the hoop on all that, both with the new ones that are immediately applicable, but also with the potential ones, and then watching what kind of deals are happening, and how that might benefit them if they stay close to those. So in terms of deal making, also a couple quick kind of just news updates on that front. Folks remember that South Korea uh, did, or the White House announced that there was a bit of a framework in place with South Korea. This was way back in July, and I think it was only announced on Truth Social. And they've been working out some of the details since then. The tariff piece of it was actually pretty straightforward. If a deal was struck, then the 25% that applied to South Korea and imports into the US would instead be reduced to 15%. I think that was, basically agreed. But the other provision there, which again, that's something we're seeing that we haven't seen in the past, but seeing this year in some of these trade deals, there are other elements to the deals that are beyond the tariffs. And in this case, the element was that South Korea was going to invest 350 billion in U.S. energy products. But again, the details of that, it sounds like from reporting, are still being worked through, and so that one is a deal that's kind of remains open. A little bit of tit for tat that's leaked out into the public between the two countries on that. Um, uh, an announcement, I think just yesterday or a couple of days ago on Truth Social, where President Trump said, I'm just going to read this with respect to India, which, China is the big one. India is probably the second largest one, and both those are we get snippets in the news of how those are going. India, he says, I'm pleased to announce that India and the United States of America are continuing negotiations to address the trade barriers between our two nations. I look forward to speaking with a very good friend, Prime Minister Modi, in the upcoming weeks. I feel certain there will be no difficulty in coming to a successful conclusion for both of our great countries. So really just kind of an optimistic update, even though there have been, meaningful tensions between the countries as they're working on sorting out what a trade deal might look like. Okay, and then another interesting update this week is that the Supreme Court basically accepted, granted cert, so it would accept the review of the IEPA case, and with oral arguments to happen here in the next few weeks. And so, what is a decision? What timing of that could be relatively soon. I'm going to ask Dave to weigh in here in just a second, but one thing I wanted to just sort of call out is if you look at the decision that the Court of Appeals took in August 29, that 7-4 decision, a first read of that makes it look like they absolutely saw no authority for the White House to under IEPA to implement tariffs. But if you look at it a little more closely, you'll read that they used words like, we don't see that there's, quote, unlimited authority, and we don't see any limits on the president's power to impose tariffs. So there's an implication there that IEPA can be read, or at least they weren't willing to go so far as to say it couldn't be read to include tariffs. So there is that suggests, at least Dave, maybe there's some kind of middle ground there. Dave, do you want to weigh in on this? I listened to your update just the other day on Bloomberg, and I found it super interesting. Some of the potential outcomes that you were describing in terms of how the Supreme. This is all just kind of fun. We'll know for sure here in a few weeks, but I think it's interesting and good for people to realize that there are a range of potential outcomes that the Supreme Court could reach.
Sure, yeah, and I'll just stick to the potential remedies that could come out of this. One, there could be no remedy, right? If they uphold the tariffs, then nothing would happen. Two, they could say something to the effect that the tariffs here are illegal, although IEPA does allow tariffs, which then would open the door to a second IEPA-based set of executive orders from the president, which I would assume he could issue fairly quickly, along with some other authorities to keep tariffs in place. So there would be effectively no change, really in the tariff rates. There would just be a different legal authority substituted for the current one. And then three, sort of on the other end, they could say, we don't think IEPA authorizes tariffs either at all, or in a very limited and constrained manner, in which case then I think the administration would have to go outside of IEPA, and they can, and there are tools they could use to do that, to impose tariffs moving forward. And a big question for the business community is what would the refund situation look like? And that's also very complicated. It could range from no refunds to sort of an automatic refund process given the importers if they were struck down.
Going back to the point you made about potentially saying that the tariffs are potentially applicable, but in this case they weren't implemented correctly. What would be? I mean, could you see kind of a bifurcation where the Supreme Court says, well, we buy the argument that maybe the fentanyl is an emergency. We don't buy that the trade imbalances are. Is that what you were suggesting, or something broader or different than that?
Well, I think they could. Yes, what you just described is possible, although to reach that decision, they'd kind of be going off in a different direction to look at the underlying emergency basis that President Trump used. But it's sort of like, how broadly does the Supreme Court want to issue a ruling here? And Chief Justice Roberts has often said he likes to have narrow rulings, so I'm not sure he in particular would be that interested in saying something like IEPA doesn't authorize tariffs, not ever. But we'll see.
Yeah. Good. And then on your point about how this would be unwound, it seems like it would be on the one hand, it feels like it'd be next to impossible to unwind the hundreds of billions of dollars of tariffs that have been collected, but that might not necessarily be the case, right? There might be mechanisms that could be deployed.
Right. When customs collects the tariffs, if you're an importer, you work with your broker, and it's sort of automated. You put in the tariff number, you put in your country of origin, and it auto populates your 7501 import declaration with the amount of IEEPA tariffs owed. And then that data resides with the government. And so at least the core of the tariffs, most of the tariffs, all of that data is readily available for the government. Now, it'd be a massive scale for them. President Trump and Secretary Bessent said upwards of 750 billion to $1 trillion. So that's a lot of money, and it would presumably take time. But I think that if they had to do it, they could do it.
Yeah, and it's funny because that was a point. I'm just sort of looking at my notes here. That was a point that in their petition for cert, that the U.S. made that point. They said it'd be very difficult to unwind all these, and if we did, it would of course undermine the administration's all the things they've been trying to do to address these emergencies. So I think that, but then recently in the news, Bessent has said, if we need to return the money, we'll do it. We'll figure it out. So I think, maybe it's exactly what you said. It'd be a Herculean effort, but the systems are in place. It's more just kind of I don't know. It's not like they can't do it. It's just it's a lot of labor, a lot of hours, but the systems would allow for it.
Yeah, and that's just purely on the refund side. I mean, keep in mind, if they were to say these were illegal, then it's sort of like, well, what about the framework trade agreements?
Yeah.
There you can't. That would be very difficult to unwind, and I suspect the administration would just say they continue to be in effect, and we have Plan B that we're imposing the tariffs, and so nothing's changed.
Yeah.
But the impact on the negotiations is kind of tricky and hard to see how that would all play out.
Yeah, I've heard it said that this Supreme Court case, it feels like it's a, kind of an, I don't know, not routine, but an economic case about tariffs. But the significance of it, of course, is huge, not just because of the scale of what's going on, but like you just mentioned, Dave, all the geopolitical impacts. It kind of, Supreme Court is, and I know they look at this stuff, they're being asked to kind of, if they rule one way, if they rule definitively against the IEEPA authority, it kind of sets 6 months of diplomatic relations back, and it's a lot. It's a lot in front of them. I think a lot of people, and I'm one of them, expect the Supreme Court to find some way of parsing through it that leaves a lot of this in place. But we'll see.
Mm-hmm. Yeah.
Okay, cool. Well, let's go to, I think, thanks for helping me on my piece, Dave. I'm gonna be done, and you'll cover an equally fascinating topic here.
Yeah, and I'm going to go through my topic very quickly here, transshipment. I have slides, which I'm going to tick through, and Troy, just go ahead and jump in anytime here if you have questions or want to talk through a topic in greater detail. Okay, is that showing up for everyone? Okay. So just very quickly, I'm going to cover briefly what traditional transshipment means, because it's important to explain where we're going with this. The second thing I'll point out is how transshipment is grafted into Trump's executive orders. I'm going to say what transshipment does not mean, and then what I think it might mean, and a couple of thoughts about things companies could do right now to get ready for what transshipment means. So to set the table, traditional transshipment involves some combination of an exporter deceiving someone as to the origin of its product. It could be sending it from one country to a third country and relabeling it. It could be just routing it through a third country, pausing it in a third country, or some sort of misrepresentation as to what the actual country of origin is. And then the second element is, which is the legal importance of it, is when it is misdeclared to U.S. Customs. So that could be an importer knowingly avoiding the tariff by lying to Customs, essentially. But it could be unknowing too, because an importer has to rely on what their supplier gives them in terms of documentation, which creates, you know, a misalignment, right? The importer is legally responsible for the consequences, but they have to depend on their exporter to give them the information they need to accurately declare the country of origin of their import. So there's lots of traditional examples where this has come up. You know, from the very beginning of my career, was involved with transshipment issues, particularly relating to anti-dumping and countervailing duty orders. Here's an example of a False Claims Act case where the DOJ imposed penalties for a company for getting the country of origin wrong and evading duties. I believe this was a transshipment case involving, you know, a company saying something originated from a third country that wasn't subject to a higher tariff rate in order to get the lower tariff rate. So moving to today, why do we care about this? What's the importance of it? This is just one example of a transshipment clause from the executive order President Trump signed with respect to Canada. And the transshipment clauses are really designed to prevent importers from being able to get the benefit of a lower tariff by transshipping goods through another country. So in this case, we're talking about Canada. It would be basically saying something was Canadian origin under the USMCA agreement when it in fact wasn't. And so the executive orders impose a tariff of 40% if you misdeclare the country of origin. And this,
Yeah, and Dave, just to break it on that for a second, I think that so the executive order added that on, you know, for if it was done in connection with Canada, the Vietnam, I think it was trade deal. It was almost announced as if that 40%, you know, similar 40% tack on was part of the deal, which was interesting because, you know, was that negotiated, or did we just kind of? So it's funny that in some cases it's almost like a negotiated penalty, and as opposed to, you know, compliance and just legal restriction as we're used to seeing it.
Yeah, and that's a great way to frame it, because I think that announcement of the Vietnam deal was intended to show what we can expect with respect to the other trade deals that are reached. And so they're sort of saying, you know, no matter what, if you're misrepresenting the country of origin, we'll push you up into the 40% tariff rate, rather than getting the benefit of the Vietnam agreement, or in this case, the Canada arrangement, which is slightly lower than other reciprocal or fentanyl related tariffs. So, you know, this raises a question, you know, what does this mean? Are we talking about traditional transshipment? Are we talking about something else? You know, I think it's unlikely that all this means is if you're committing customs fraud. I think you have to look at this in the context of there likely is going to be some sort of in-between rule of origin that is defined as transshipment. And we don't know this because the trade agreements are just framework agreements at this point. And so they haven't, you know, we've seen like fact sheets about what the agreements mean, but you know, it's my understanding they're still negotiating significant provisions of the trade agreements. And so in the future, we may have more clarity on what this means. But you have this traditional customs fraud concept in trade law. And then on the sort of the opposite end of it, you have substantial transformation. So if you're sending things to a third country where significant assembly or manufacturing occurs, there's what's called a substantial transformation of those components occurs, and then that changes the country of origin. And so transshipment can't be something along the lines of substantial transformation, because that's the rule of origin that defines how products are treated for purposes of the IEEPA tariffs, as well as the 232 and 301 tariffs. So what does it mean? You know, we don't know, and it remains to be seen where they'll come down on this issue. You know, I put in this slide the example of like a China-specific rule of origin, and it's possible they'll do something like this, not just for China, but maybe certain other countries that have higher tariff rates. But the idea being that you can't get away from whatever China's tariff rate is if you have certain percentages or types of components that are sourced from China. So if you're making something in Vietnam, to use Troy's example, if you have 40% content from China that you're assembling in Vietnam, they could create a rule of origin that just says, you know, that is for purposes, either the Vietnam agreement is not a Vietnamese origin product or is considered to be transshipping. And they could do different rules of origin in different agreements. There's also product-specific rules under what are called tariff shift rules. Those are, you know, there are hundreds of those in the USMCA agreement and other free trade agreements. It's possible they would do something that's more targeted at particular products rather than just a blanket value threshold. And they could do a combo of these two.
Like automobiles or something. Yeah, Dave, well, where would the guidance, I mean, it could be that in some of these cases, the trade deals, we don't really ever get more. I mean, they kind of are what they are, these frameworks. And if that's the case, do you think Customs and Borders with CBP will provide more guidance as the regulator, or do we think we'll just kind of, you know, absent the USTR providing it as part of the deal, we'll just be kind of working our way through without any clear guidance?
Yeah, it's not really I don't know. I mean, customs would have that authority, Troy. I think they have to confront the issue if they're not directed to do so by USTR Commerce through the trade agreements. You know, they have a legal obligation to apply the law, and so would have to sort this out. It's possible customs would just say something like, every time you get the country of origin wrong and you pay a lower tariff rate as a result of getting it wrong, then we're gonna call that transshipment and kick you up to the 40% tariff rate. So that is a possibility. I suspect it'll mean something more than that. It's also possible importers will go to customs and force them to say, like, what do you mean by transshipment, and how do I know when the 40% tariff rate applies? Because importers can do that. So just very quick, and then I'll be done. So how to prepare now, sort of no matter what the outcome is here. I mean, I think given all my message, I guess, would be just on the whole, given all the different tariff rates out there, you know, it wouldn't be surprising for any supplier to be getting inquiries from their US purchaser, like, can you please prove to us we're getting the country of origin correct? Because if you are aware of, you know, cross-border supply of components that are going into your product that you're imported, you know, you need to understand, so you can understand the risk that's associated with the import, how it's made and what its componentry is. And so a few other ideas here in terms of documentation and preparation. And then I was going to turn it over to questions. Or Troy, thoughts on the issue?
Yeah, I've got, well, maybe just one more follow-up question on this. So we mentioned, you know, Vietnam and Canada. Are there any other countries so far that have been mentioned as this kind of, you know, in between, this new concept is applicable to?
Well, I mean, I guess my thinking would be, I'm curious at either how the rules of origin or the transshipment issue is defined with respect to China, because I think the underlying assumption is China will be subject to some sort of tariff rate that's higher than many, maybe not all, other countries. And we do so much trade with China, and China supplies so many inputs. So that's kind of the big one I'm keeping an eye on, but it's possible this, you know, there could be many different variations of the rules of origin and transshipment that come out of the negotiations.
And the 40%, is that that's an additional tariff if someone has sort of transshipped, so to speak, is it on top of the tariff that they're getting, that would be, like, let's say in the case that that a product was transshipped from China to Canada, and then a US importer brings it in, is the 40% on top of the Canadian tariff, or on top of the China tariff in that scenario?
Yeah,
If
I
that
think
question makes sense.
it would be like the 40%. So say China ends up with a 30% tariff rate as a result of all the negotiations. I think if you were found to be transshipping, even though it were a Chinese good, you wouldn't get the 30% either, you'd get 40%. That would be your IEPA rate. And then these clauses also provide for penalties on top of that for getting it wrong. So there could be an added stick from customs for getting it incorrect.
Yeah, but as far as we know, none of this has been enforced yet, that we've seen.
Not publicly, right?
Yeah. Good. Okay, Dave, I think that's super interesting. I think that's one that we've seen in the announcements and heard about, but it remains pretty unclear as to what it'll mean over time. I suspect, like everything, it will become clearer over time, and it'll probably be, again, one of those new realities that we're living with. I think a lot of these, they feel so fresh, we think, well, maybe they'll go away as fast as they came, but I think a lot of these, we need to be prepared, will be here for the foreseeable future.
Yeah, and one thought here is I could see this being an industry specific sort of it being administered differently in different industries. Like we saw customs recently took a pretty hard line with respect to marking and origin of pharmaceuticals. And I could see them, if they catch wind of, industries or areas of the market where they suspect transshipment or customs duty evasion is occurring, that they would, send out very strong signals to put everybody on notice that, there'll be consequences for doing that.
It's surprising to me that this hasn't been talked about more. Obviously, Canada makes sense because it's part of USMCA. Mexico is where more stuff, we're more, I think this is alleged to have been happening over the last several years, where you had kind of Chinese manufacturers basically putting plants in Mexico. So it's interesting it hasn't happened there yet. It's also even more interesting to me because the Mexico-US discussions seem to be going pretty well. I mean, over the last few days, we saw Mexico taking a beating from China because Mexico was implementing tariffs on Chinese imports into Mexico, kind of at the behest of the US. And so Mexico seems to be relatively cooperative. But maybe that just means that we will see that, but as part of an announcement here before too long.
Yeah, and shifting focus a little bit, but I do think one thing that's really interesting that seems like it's imminent is the administration's going to announce their Section 232 national security tariffs on semiconductors. And they've said that they're going to impose some sort of regime where tariff reductions are allowed for investment in the United States. And so you brought up Chinese investment into Mexico, and they're trying to redirect investment into the United States and offer sort of tariff carrots, if you will, for doing that. I don't know what that will look like ultimately, but.
Well, it's a good reminder of how interesting this, it's painful, so don't discount that. And the uncertainty is high, but it's different. And I think the quicker that all of us continue to realize and appreciate the difference that the way I guess the game is played versus in the past, and deal making is a part of that. As before it was all about protectionism. Now it's protectionism still, but also about, like you just mentioned, Dave, bringing investment into the US. It's deal making, and really almost anything's on the table. And businesses, we see really large businesses already at the table, kind of cutting deals. Boeing is getting some investment directly into it because of the deal with South Korea. I think Utah businesses and maybe sectors and industries can do a similar thing, can get together and sort of have ideas and proposals that maybe some of these deals can be beneficial in some way. So anyway, I know we're out of time, but that seemed like a nice thing to end on. And Rayanne, back to you.
Thank you. Yes, seeing no questions, I think we're good to wrap up. So thank you, Troy and Dave, for taking the time to speak to us today. Thank you to everyone who tuned in this week. If you'd like to stay updated, feel free to monitor our website, the Tariff dashboard, as well as any upcoming events. You can also stay tuned by signing up for our newsletter, which you can also find at the bottom of our website. If you have any questions, feel free to reach out via email to us at info@wtcutah.com. Otherwise, we hope to see you all again next Friday.